Good afternoon. Welcome to Grace and Gavel, where truth meets compassion. Today we're talking about the ethics of retrial, when new evidence contradicts a guilty verdict. We like to believe that the justice system corrects itself, that when mistakes happen, new evidence will fix them. But the reality is far more complex and far less comforting. Today we're talking about what happens when new evidence emerges after a conviction, and why proving innocence can be harder than proving guilt ever was. The myth of automatic correction. A guilty verdict carries finality. And the other thing is, it's not just about the defendant, it's not just about the prosecution, it's not just about the defense attorneys. If this is a crime involving victims, then you have to be concerned with the victims, because victims have rights, and their rights can be trampled depending on what is occurring. And so it's not because the system believes that it's perfect. It knows it's not. It knows that there's mistakes. Hence, we wouldn't have appeals, right? But because it values closure, and closure is something that victims are concerned about. Victims and survivors are concerned about. Finality protects resources, it protects victims, and it protects public confidence. But it also resists reconsideration, even when new evidence appears. Let's talk about Act 2. Post-conviction relief is not an appeal. Once a conviction is final, the rules change. Post-conviction relief mechanisms like habeas corpus are narrow by design because of the finality, because of the people involved, the moving pieces, such as the prosecutor, the defense attorneys, the defendant itself, right? And they're narrow because ultimately they want things to have a final result, a final outcome, not just for the victims, but for everyone who's involved. The family of the victims, for instance, especially if somebody was murdered. I mean, you don't want to have to keep going through and rehashing that over and over and over again, because that is trauma that is going to happen to someone. Trauma of reliving things, post-traumatic stress, all of that, all the symptoms and the side effects that go along with being involved in the system. As a victim's family, or as the victim yourself, or various other things. So courts often ask, could this evidence have been discovered earlier? If the evidence could have been discovered earlier, it's likely to be potentially said, this really isn't a habeas issue. Does it fundamentally affect the outcome? Is it reliable or merely conflicting? New evidence is not enough. It must be extraordinary. For instance, something like a Brady violation, right? If the prosecution had information that would have potentially affected the culpability of the defendant and they held it aside, such as they found a fingerprint maybe that wasn't from the defendant, or some sort of idea about like holding a gun or something like that, meaning that they realized that the forensics didn't match the gun that the defendant was charged with having carried and shot someone with. That's exculpatory evidence, which means evidence likely to not prove the guilt of the person that they said did. It's exculpatory, so it needs to be disclosed to defense counsel. If you have a prosecutor who's overzealous and is not giving all the evidence that needs to be received, including exculpatory evidence, which is really important, that would be considered like a Brady violation. DNA. Imagine finding a third party's DNA. Let's say that there was a sexual assault that was alleged, and they had been saying forever, oh, it's John's, it's John's, it's John's. And then you find out later that when they actually did the DNA testing, it wasn't John's DNA. It was Bob's DNA, right? So that is exculpatory evidence for your client, right? And the prosecutor should have turned it over. That could be potential misconduct for the prosecutor. because they know what they are supposed to do. DNA testimony and the burden of finality. DNA exonerations force the system to confront its own fallibility. But even DNA is not a universal key. New testimony, recantations, or expert disagreement often fail. Not because they're untrue, but because the system prioritizes stability over uncertainty. The question becomes, how wrong must a verdict be before we reopen it? And ultimately, I would say that if somebody is serving time or looking at a death penalty situation, or if there is reason to believe that there has been tampering in the system some way, why shouldn't we err on the side of looking into it to make sure that no one is doing time for a crime that they didn't commit? I think that's fair. Because ultimately, yeah, they may end up getting a settlement from the state at some point, but that doesn't give them back their life. They have family too, and if they're being falsely accused or falsely incarcerated, wrongfully incarcerated, there needs to be something done about that. Just like, yes, the victims do deserve finality. I'm a big person on victims' rights, absolutely. They deserve finality, but they shouldn't be getting the blood, so to speak, from someone who didn't do anything to them, right? And so the other thing is there's a lot of times where, yes, they get that judgment, but ultimately there is misconduct there. There's things that are being done that don't need to be done, because sometimes you have a prosecutor who is so focused on getting this particular defendant because they believe that they're guilty, but they look at it as wins or losses. And ultimately, prosecutor really shouldn't be looking just for a win. He should be looking for the law, what the law supports, what the evidence supports, not just wanting to win for winning's sake. And so Act 4, justice versus closure. Retrials reopen wounds. They unsettle narratives. They threaten institutional confidence. And so courts walk a careful line between correcting justice and preserving finality. That balance is ethical, but it's not always comfortable, because balance, as we've talked about before in prior podcasts, can essentially be an illusion, right? Because sometimes you swing one way to the left or maybe a little bit to the right. Balance can be a myth sometimes, ultimately. And you have to make the decision, what side are you more likely going to be on? So in closing, a justice system designed by humans must acknowledge error. They must admit, especially if there's a lot of distrust, which there seems to be a lot of distrust in the court systems here lately. If there is distrust in the system, they need to acknowledge error, right? Acknowledging error is like, we are human, we make mistakes, but we got to get better. How do we do that? Let's try to focus on making things better and easier and just and fair. But acknowledging error is not the same as correcting it. And when new evidence collides with an old verdict, the law does not ask what feels fair. It asks what it can tolerate reopening. Because not only are you reopening the case and the verdict and the things like that, you're also reopening wounds for people who may have been victims in those crimes. And that's another thoughtful thing to consider, victims' rights and how the system can potentially cause a lot of trauma and a lot of distrust, like in the local communities and around surrounding communities. So thank you for tuning in to Grace and Gavel, where truth meets compassion. And I appreciate each and every one of you. Thank you very much. And I hope you have a great rest of your day. Bye-bye.